Hey everyone, Mr. Jeffersonian here, and if you haven't heard about Anchor, let me explain. It's the easiest way to make a podcast. First off, it's free, and who doesn't like that? There are creation tools that allow you to record and edit your podcast right from your phone or computer, and Anchor will distribute your podcast for you so it can be heard on Spotify, Apple Podcast, and many more. You can make money from your podcast with no minimum listenership. It's everything you need to make a podcast all in one place. So the call to action is download the free Anchor app or go to anchor.fm to get started. Howdy everyone, and thank you again for tuning in to the Jeffersonian Tradition. Before we get started, I have a couple of things to go over. For now, the podcast is mostly ad-free, and I sure would like to keep it that way. You can help me out with that by becoming a supporting listener. If you find value in the podcast, there's a link in the show notes page that will enable you to contribute to my work and to help keep the podcast going and keep it light on advertising. Contributions start as low as 99 cents per month, with two other brackets at $4.99 per month or $9.99 per month. If you're not comfortable with a recurring contribution model, I've also set up a Cash App profile for the show. One-time contributions can be sent through Cash App to the show's cash tag, which is $ Mr. Jeffersonian, and all of this information will be listed in the show notes page as well. Any contribution amounts help, and thank you in advance to anyone who chooses to pitch in. And if you like the show, then please be sure to subscribe and turn on notifications for it. We are now available on all major podcast platforms. And to help the show grow, make sure to share it with your friends and family. In other show-related news, if there's a topic you'd like for me to cover, or if you just have general questions for me, I can be contacted at the show's email address, which is mrjeffersonian@outlook.com, or through the show's MeWe group, which is also titled The Jeffersonian Tradition. And if you're not on MeWe yet, then seriously, what are you waiting for? Unlike a certain other social media platform, MeWe respects the right to free speech and offers a privacy bill of rights. So if you'd like to be a member there, then download the MeWe app and search for me at the username Mr. Jeffersonian. The show group is private, so we must be contacts before I can send you the group invite. If you're not familiar with MeWe's platform, contacts are the same as being friends on Facebook. With all of that fun stuff out of the way, let's now turn our attention to the topic for today's episode. All right, so today we're going to talk about the NCL lawsuit against the state of Florida again. So this will be a follow-up episode to episode number 8. If you want to get the full context, make sure to check out that episode, and then you can come back and listen to this one. So this is basically going to be a Jeffersonian response because NCL did win the initial injunction against the state of Florida. Just one other point of business before I get started today. Wednesday's episode is going to be an interview with Texas gubernatorial candidate Don Huffines. Y'all please make sure to tune in for that episode. Senator Huffines is all about states' rights and governing Texas for the benefit of Texans. And I am begging y'all, literally I am begging y'all, please share that episode like wildfire so we can help his campaign reach people and get him in office because he would do magnificent things for the state of Texas. And all right, let's go ahead and move forward on today's topic. So as mentioned, NCL has won, and NCL is Norwegian Cruise Lines. So NCL has won the preliminary lawsuit it filed against Florida. And recall from episode 8 that Florida passed a state law forbidding cruise lines from requiring vaccine passports from their customers. This law carried a fine of $5,000 per violation, so it had some pretty sharp teeth as far as enforcement. Other cruise lines carried on mostly business as usual in light of this law, but NCL got it in their head that this law would be detrimental to their business and ensuring the health and safety of their passengers and crew. And then I'm going to read y'all a summary. This is from reason.com, so just a summary of the initial hearings. In yesterday's Norwegian Cruise Line Holdings Ltd v. Rifkes, Judge Kathleen M. Williams issued a preliminary injunction against Florida's ban on businesses requiring proof of vaccination. Judge Williams held that the law likely violated the First Amendment because it was a content-based restriction on the speech that businesses can demand from customers. What is that? Since when, public or private, when can anybody compel you to say something or force you to say something? Section 381.00316 is a content-based restriction because on its face it draws distinctions based on the message of speech. In other words, it is apparent from the text of the law that speech is regulated differently because of its subject matter and content. The statute prohibits businesses from requiring their patrons to present documentation certifying COVID-19 vaccination or post-infection recovery for access or services. Florida Statute 381.00316. However, nothing in the statute prohibits businesses from demanding documentation of a negative COVID-19 test or any other type of medical or informational documentation. In fact, because the statute allows businesses to institute screening protocols to protect public health, business entities are expressly permitted to require this type of documentation, including COVID-19 test results, other vaccine documentation, and other types of medical information. Under Section 381.00316, the only documentation businesses cannot demand is COVID-19 vaccine documentation. Accordingly, the statute is a content-based restriction because it singles out documentation regarding a particular subject matter, certification of COVID-19 vaccination or post-infection recovery, and subjects it to restrictions. Businesses may not require them for entry or services that do not apply to documents regarding other topics. So we need to talk about that. So if that's the case, based on what they're saying there, so Florida's law, in my opinion, should have gone further and just said you can't require any of this stuff. But just taking this at face value, where in the Constitution does it say a business can compel you to provide information about yourself? Now, granted, I already know, I hear it now. People, conservatives, libertarians alike, are going to come back and say, the Constitution does not apply to private businesses. Okay, fine, but then they don't get that protection. That would be my takeaway or my argument in response. But again, is this a world we want to live in where a corporation can force you to provide certain types of speech? In this case, a vaccine passport. They can force you to do that or say, go away. And who knows, they probably won't have to give you a refund because they're going to say we had it spelled out plainly in the terms of service. So, but let's read the First Amendment. And this is from the U.S. Constitution. First Amendment says, Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof, or abridging the freedom of speech, or of the press, or the right of the people peaceably to assemble and to petition the government for a redress of grievances. Notice it says Congress, as in federal Congress. There is nothing in there that says a state cannot restrict this totally distorted view of what constitutes freedom of speech, because the Bill of Rights does not apply to the states. The Slaughterhouse cases determined that. And actually, there were other cases prior to, even under the Marshall Court, they said that the Bill of Rights does not apply to the states. So, okay, well, now let's see what the Florida State Constitution says on the matter. So this is from Florida's Constitution, Article 1, Section 4. Every person may speak, write, and publish sentiments on all subjects, but shall be responsible for the abuse of that right. No law shall be passed to restrain or abridge the liberty of speech or of the press. In all criminal prosecutions and civil actions for defamation, the truth may be given in evidence. If the matter charged as defamatory is true and was published with good motives, the party shall be acquitted or exonerated. And again, there is nothing in that says a corporation has a right, or a business of any size. So a lot of times people say corporation and it's like, oh, you mean places like Walmart or places like Goldman Sachs. No, a business of any size. There is nothing in there that says a corporation has a right to demand or compel speech or content from its customers. That is a grotesque distortion of the right of freedom of speech. I mean, that is utterly grotesque. And just the very thought of that. Now, if this is the game that they want to play, so for this federal judge who determined this is judicial activism at its worst. And if that's the game they want to play, and we're going to apply the Constitution in this manner, then what about the Fifth Amendment, the right to not self-incriminate or the right to remain silent? Oh, I guess it's convenient to ignore that. So this is problematic for quite a few reasons, but the primary points of focus for us today are going to be the nationalistic aspect of this and the incorporatist view that NCL used, and the problem with allowing the federal judiciary to determine the extent of the general government's power. The big questions here are federal judicial tyranny and who gets to determine the extent of the general government's power, and should a state have the ability to set parameters for operating a business within its boundaries. We're going to turn back the pages of history and ask Thomas Jefferson what he thought on judicial activism and judicial tyranny. So we're going to address the first part of that question first. So this is going to be the first resolution from the Kentucky Resolutions of 1798. And it says, quote, "Resolved, that the several states composing the United States of America are not united on the principle of unlimited submission to their general government, but that by compact under the style and title of a Constitution for the United States and of amendments thereto, they constituted a general government for special purposes, delegated to that government certain definite powers, reserving each state to itself the residuary mass of right to their own self-government, and that whensoever the general government assumes undelegated powers, its acts are unauthoritative, void, and of no force. That to this compact each state acceded as a state and is an integral party, its co-states forming as to itself the other party. That the government created by this compact was not made the exclusive or final judge of the extent of the powers delegated to itself, since that would have made its discretion and not the Constitution the measure of its powers, but that as in all other cases of compact among several parties having no common judge, each party has an equal right to judge for itself, as well of infractions as of the mode and measure of redress." That is a powerful statement. What Jefferson is saying there is states are supposed to be the check on general usurpations. Now, in this case, you have a federal judge literally overturning state law from the bench. When last I looked, the legislative body was the only body that could repeal state law or refuse to enforce it. But no, you have a federal judge overturning state law from the bench and siding on the side of a corporation to say you have a right to force people to show papers. That is abhorrent. And I mean, look, I get it. With regular travel passports, if you're going abroad, I get it. But this is not that. This is a private corporation saying, if you want to do business with us, you will submit to this jab. You will get this vaccine. And that is horrendous. That is absolutely horrendous, because they can exclude you from participation in the economy based on these grounds. Because if one company can do it, multiple companies can do it. And we're already seeing that. Some cities are starting to do this. And I think those states need to smack those cities down. New Orleans, New York City, San Francisco, LA. I think those state governments need to smack those cities down. So next, I'm going to read to you again from Thomas Jefferson's thoughts on the matter. This is an excerpt from the 9th and final resolution of the Kentucky Resolutions of 1798. And here he says, quote, "In questions of power, then, let no more be heard of confidence in man, but bind him down from mischief by the chains of the Constitution." End quote. And so there, again, he's saying, now, Jefferson was ever the optimist when it came to what he thought humans could achieve. But Jefferson himself is saying, look, confidence in man has failed. Bind him down by the chains of the Constitution. Again, Florida state constitution doesn't have anything in there saying that they could not pass this law. The general constitution doesn't apply. So it is up to the state of Florida. Stand up, lean on the 10th Amendment, and put this federal judge back in her place. And again, another thought from Thomas Jefferson. This time, this is an excerpt from a letter he wrote to Spencer Rowan. And at some point, we're going to do a whole episode dedicated to Spencer Rowan. But Rowan was a close friend and confidant of Jefferson. And he was also the Chief Justice of the the Virginia State Court of Appeals. So now it's the Virginia Supreme Court, but in his time it was the Virginia Court of Appeals. So in this letter, Jefferson writes, quote, "For experience has already shown that the impeachment it has provided is not even a scarecrow." And he's talking here specifically about the alleged ability to impeach federal judges that failed miserably when tried. So, for experience has already shown that the impeachment it has provided is not even a scarecrow, that such opinions as the one you combat, sent cautiously out, as you observe also by detachment, not belonging to the case often, but sought for out of it, as if to rally the public opinion beforehand to their views, and to indicate the line they are to walk in, have been so quietly passed over as never to have excited animadversion, even in a speech of any one of the body entrusted with impeachment. The Constitution on this hypothesis is a mere thing of wax in the hands of the judiciary, which they may twist and shape into any form they please. And again, in this letter, Jefferson was emphasizing the failure of impeachment as a means of removing highly partisan federal judges in the terrible decisions of the Marshall Court. But what he's saying is, if they have the unlimited power of judicial review at the state level, the federal level, in all cases, then their power is limitless, and they can make of the Constitution whatever their mind tells them it is. And we're seeing that. We are seeing that right here. The judge literally said businesses have a right to compel this sort of speech. That's awful. That is absolutely awful. So now let's see what Spencer Rowan had to think or had to say on this subject. So we're going to start the first quote or the first excerpt is going to be his thoughts on the apathy of the Virginia populace in accepting some of the decisions of the Marshall Court, or the lack of alarm. So he says here, quote, "I must say to my fellow citizens that they are sunk in apathy and that a torpor has fallen upon them. Instead of that noble and magnanimous spirit which achieved our independence and has often preserved us since, we are sodden in the luxuries of banking. A money-loving, funding, stock-jobbing spirit has taken foothold among us. We are almost prepared to sell our liberties for a mess of pottage. If Mason or Henry could lift their patriot heads from the grave while they mourn the complete fulfillment of their prophecies, they would almost exclaim with Jugurtha, 'Venal people, you will soon perish if you can find a purchaser.'" So what he's saying there is, in his perception, the people weren't even worth the price it would take to sell them all into slavery, and that they were getting ready to sell their liberties for a mess of pottage. So Spencer Rowan already saw the problem with federal usurpation through the judicial branch. And again, this was all taking place back before 1820. This is something that has been a problem for a very long time, and this is why legal incorporation is so dangerous, because you're leaving up to, essentially, if it makes it to the Supreme Court, 9 unelected, unaccountable lawyers who will make of the Constitution as they will. The Constitution is what they say it is. And even on the federal benches throughout the country, there's no way to get rid of them. I mean, yes, impeachment technically is there, but in all practicality, it's not going to happen. And these people are not elected from the people in the state. They're appointed. So there's no accountability here whatsoever. Now, Rowan also balked at the fact that some Jeffersonian judges had sided with the Marshall Court, and in his Hamden letters he lamented, quote, "They have undergone the common fate attending the possession of power. Few men come out from high places as pure as they went in. It is only the elect who can pass unhurt through a fiery furnace," end quote. And gosh, I just have to stop and admire the eloquence and passion of the older American generations. But is this not totally relevant today? You get people, again, they get in these positions through appointment, and they get so power drunk or just drunk on power, there's no accountability, and the law is whatever they say it is. And that is just horrible. Unelected federal judges who realistically cannot be impeached are passing judgments that are in total opposition with the state government's laws. I personally think even John Marshall would have his eyebrows raised at what we're seeing today, because even Marshall didn't go this far in most cases. Now, Rowan also completely eviscerated the idea of federal judicial supremacy by quoting none other than John Marshall himself. Per Rowan, the following was said by John Marshall at the Virginia Ratifying Convention. So allegedly Marshall said, quote, "I hope no gentleman will think that a state will be called at the bar of the federal court. It is not rational to suppose that the sovereign power should be dragged before the court," end quote. John Marshall said that. talking about state sovereignty. And one final thought today from Rowan, quote, "No calamity would be more to be deplored by the American people than a vortex in the general government, which should engulf and sweep away every vestige of the state constitutions," end quote. And again, NCL didn't even try to bother taking this through state court. They went directly to the federal court system, and the federal court system turned directly to the general constitution, or the Constitution for the United States. There was not even a debate on what the Florida state constitution says, so why even have it there? And that's what Rowan was saying. Again, 200 years ago, Rowan saw what would happen if the judiciary was left unchecked. So Florida they're actually in the process of appealing this, and they're playing a losing game because they're appealing to another federal court. This is the Jeffersonian response, or this is what I would like to see them do. 1, ignore the federal court ruling and enforce your laws. You made these laws on behalf of the people of the state of Florida. Enforce your laws. Forget what the federal court says. 2, lean on the 9th, 10th, and 11th Amendments. And there is a caveat to this. NCL sued an individual within the State Department of Health. So technically, the 11th Amendment may not apply here, but that's why the state should fall back on the 9th and 10th Amendments. NCL has every opportunity to carry on their operations in states allowing this crap, such as New York and California. And again, there were other cruise companies in the state of Florida who just carried on basically business as usual. So, NCL, carry your ass. Go to New York. Go to California. Not here in Florida. That's what Florida's response should be. Ignore the federal court. Take back your state. And so those are the main ways that a Jeffersonian approach could work. But let's talk about some libertarian abstracts on this versus these real-world Jeffersonian solutions. Now, I did mention in another previous episode that I've been getting into some spirited online debates with libertarians over the whole idea of businesses being able to require vaccination status. And I've encountered a loud group of them who see absolutely no problem with private companies requiring proof of vaccination for employees and for customers. And their stance boils down to, if any level of government can tell a company how to run its business, then the owner isn't really the owner. They also argue that one is free to work or shop somewhere else. In Ancapistan, they'd be 100% right. But the real issue here, what we really need to ask ourselves, is since the government does exist, and we're not in Ancapistan, but in the real world, since the government does exist, what is its proper role? Is it to protect the rights of individuals, or is it to be a shield for business in every single case? And again, just to reiterate, we do not live in an abstract world. We live in a very real world that has very real consequences. My personal belief has evolved to total decentralization based on states' rights. I have no issue with states setting regulations on businesses within their boundaries, and I say that in a strict and classical sense. So to be clear, I mean regulation in the sense of to make regular. So if Colorado wants to say, look, we have this 20-point checklist. If you want to open a business, you have to agree to these 20 rules and meet these 20 conditions, fine. If Florida wants to say, well, look, we have this 5-point checklist, and if you want to have a business here, you just got to meet all 5 of those, fine. That at least gives us competition in governmental policy instead of everything being subsumed into a terrible federal policy or decision and forced on everyone. Now, specifically as it pertains to forced vaccination on threat of job loss or exclusion from participating in the economy, there's some additional questions that we need to stop and ask ourselves. 1, can an employer require adult favors from you in order for you to keep your job? No, that's illegal. Is that a bad law? Does that mean that the business owner doesn't really own their property? You tell me. But they can't do that. They can't say, look, give me this adult favor or I'm going to fire you. Not allowed. The second question we need to ask is, does an employer have ownership rights over the bodies of their employees? And if you take the libertarian approach on this and say, well, yes, because the employee is paid by the employer to do whatever the employer says, the logical conclusion of that is voluntary slavery. That is the logical conclusion. So if people want to say that that's fine, okay, but then you need to understand you are endorsing literal slavery. Regardless of how cushy it may be, even if you're making $1 million a year, that means they have ownership rights over your body, and whatever they tell you to do, you have to do. So if they say go get a tattoo, you got to go get a tattoo. If they tell you take the shot, you take the shot. This is not a world I personally want to live in, and that is not okay in my eyes because, again, slavery is an institution that's been gone for 160 years. Why bring it back? Why bring it back? Again, even if it's voluntary, you can pick your master and your master has to pay you. But at the end of the day, they are your master. Why bring that back? So anybody who's wavering on this, remember that. If you say that it's a private business and they can do what they want, you are endorsing slavery. The third is, should businesses be able to exclude you from buying and selling based on vaccination status? And libertarians in general have answered this with a yes, at least the ones that I've interacted with. And again, their argument devolves to property rights. Okay, I'm going to meet you where you are. If you're somebody who thinks that way, I'm going to meet you where you are. To the point that property rights should be the ultimate arbiter here, whose ownership rights take precedence? The customer's ownership rights over their body, or the business's abstract ownership rights over its physical property? So what I mean by that is the libertarians I've encountered who take this stance, they say, well, let's say if you want to go into, I'm just going to use Walmart as an example. So far, Walmart hasn't said anything about this that I've seen, but I'm just going to use them as an example. Let's say if you went to Walmart and Walmart says, well, hey, you got to show proof of vaccination or we're not going to let you touch our buggies or use our self-checkout. Okay, fine. What's more important in that scenario? From the libertarian standpoint, what's more important there? The person's right to be safe in their person or the business's abstract right over who gets to use its self-checkout system? To me, body ownership is much more important than that. So from a Jeffersonian perspective, I think the state governments need to absolutely bring the hammer down and forbid businesses from implementing these horrible requirements. Some people will say that opens the door to an extremely cumbersome regulatory environment and paves the way for total state takeover of businesses. And to that, that's a fair point. Yes, maybe it does let them get a foot in the door for nationalization or state ownership. But my response is that individuals will have to wake up. Individuals will have to wake up and be vigilant to prevent this. And look, again, at your local level, you can vote this stuff down. So if you're somebody who thinks that voting is violence, get that out of your head. Vote in a self-defensive manner. Have a little bit of common sense. Because even if you choose not to vote, you're still bound by the rules that get set. So get involved at your local level. Get involved at the municipal level and the state level. For federal, look, it really doesn't matter. But at your local level, state and municipality, you can make a difference. Get your voice out there. Get out in the streets and oppose this crap, or it's never going to end. It's been going on for 18 months. It started off as 2 weeks. How much longer are we willing to let it go? And if you're a religious person, this is starting to look an awful lot like the mark of the beast mentioned in the book of Revelation. So in the book of Revelation, we'll recall, people had to take the mark to buy and sell or exchange, participate in the economy. With what we're seeing here, there's a lot of parallels there if you're a religious person. So we're going to go ahead and move into the wrap-up. And I know we covered a lot of ground today, but I'm telling y'all, I'm sick of the fear-mongering surrounding COVID and the cheerleading of half the population for totalitarian policies that would literally violate the Nuremberg agreements. Those people are the living embodiment of why I don't think we should have universal suffrage for people over 18. And if you're on the fence with the jab or any other part of the official narrative because of potential job loss or unpopularity in your social circles, I want you to understand that if you concede now, this never ends. It never ends. Now is when we make our stand. And I'm going to leave y'all today with an excerpt from Volume 1 of Thomas Paine's American Crisis. These are the times that try men's souls. The summer soldier and the sunshine patriot will, in this crisis, shrink from the service of their country. But he that stands it now deserves the love and thanks of man and woman. Tyranny, like hell, is not easily conquered. Yet we have its consolation with us, that the harder the conflict, the more glorious the triumph. What we obtain too cheap, we esteem too lightly. It is dearness only that gives everything its proper value. Heaven knows how to put a proper price upon its goods, and it would be strange indeed if so celestial an article as freedom should not be highly rated. Please remember, if you found value in the podcast, to consider contributing to the show. You can contribute on a recurring basis through the supporting listener link in the show notes page, or you can make a one-time contribution by using the show's Cash App information, which is also included in that show notes page. Any contribution amount helps, and thank you again to everyone in advance who decides to do so. Also, please consider downloading the MeWe app and joining the show's private group so we can have more sane discussion around historical and current political issues. And all right, with another episode in the books, thank you again for tuning in, and I'll talk to y'all next time.